The trial is where the case is decided. There is a structure and a process to how a trial is conducted. In a case that is being decided by a jury, you first must select the jurors. A pool of potential jurors are gathered, and you select your jurors from among those potential jurors through a process called voir dire, which is a questioning of the people that have been selected for jury duty. You try to find disinterested people who will decide the case based purely on the facts rather than any personal biases they have or being acquainted with the parties. The jury selection is a process that varies in how it's conducted around the country. Here in Brevard County, Florida, it is a pretty straightforward and effective process, especially in commercial cases. You select your jury pretty quickly. It might take a half a day. It could take less than that. The next phase that you go to after your jury's been selected, or if you're trying your case without a jury, is an opening statement. The opening statement is where the attorneys tell the judge or the jury, in a case being decided by a jury, what they believe the evidence will show. You have to make a good faith opening statement of what you really believe your evidence is going to be in the case. You can't fabricate things. You better be able to back up what you say. You are also limited in doing this. You're only talking about what you think the evidence will be. Your opening statement is not argument. That is saved for the end of the case. After the opening statements have been made, the trial will commence. The judge may read some preliminary instructions to the jury to tell them how the case is going to be conducted, and then you move into the introduction of evidence. The primary sources of evidence are witnesses and exhibits, such as documents, for instance, a copy of the contract. Each witness is examined by what is called direct exam, and then each witness is subject to cross-examination by the other side. You begin with the plaintiff putting on his or her case, introducing all of their evidence. There may be fights over whether something is admissible under the evidence code. There is law that governs what a court or a jury can hear in deciding a case. And the plaintiff presents all of the plaintiff's proof. The defendant then presents all of its proof in support of its case, and the plaintiff is entitled to do a rebuttal. There are mechanisms for trying to win the case after the plaintiff's case in chief, where you say the plaintiff has not met his burden of proof and therefore is not entitled to go forward. The plaintiff puts on its rebuttal case if the case isn't entered that way, and then there are closing arguments where you argue to the jury the facts as it applies to the law. In a non-jury case, you simply make legal argument to the judge, and you may submit a written memorandum of law to the judge in a lot of cases. If a jury is sitting, instructions are given by the judge to the jury of what the law is and how they carry out their duties. They deliberate in private to decide the case. Sometimes they'll have to come back and ask the judges for clarification on various points about what they're trying to do. In very rare cases, a judge may disregard the jury's findings and grant a motion for judgment notwithstanding the verdict. This is a situation where the judge believes there is insufficient evidence to support a jury's conclusion, or that the jury misapplied the law to the facts. This is very rare. There can be efforts taken by the parties after the case to attack the judgment within a very short period of time, or you can file a notice of appeal saying the court committed an error of law.